Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
Y'all can be seated. All right, good morning. Before we start our arguments today, I wanted to take a few moments to thank some folks. I want to thank Dr. Peter Moeller and Dean Bill Brubaker for their invitation to the court to have oral argument here today. As I'm sure you can imagine, it takes a whole lot of work to make this the way that it is, and we've been here since last night. It's been a great opportunity to meet a lot of folks. But I would like to specifically thank Dean Nathan Smart, Dean Candace Robbins, and Cindy Rice from the School of Law for their tireless efforts to make our visit a success. Dr. Joseph Messina, Dean of Fairfield College of Arts and Sciences, and Charles Sneed, Director of the School of Music, for allowing us to use this beautiful venue for the argument today. I would also like to extend a special thank you to Craig Caldwell with the University of Alabama, and Chief Scott Thurmond and Captain Mark Grimes with the UAPD, who worked closely with our Supreme Court Marshal Earl Marsh to secure the security of the event. And I next would like to introduce the members of our court in order of seniority. I have Justice Greg Shaw, Justice Kelly Wise, Justice Tommy Bryan, Justice Will Sellers, Brad Mendham, Justice Greg Cook, Justice Chris McCool, and Justice Will Parker. So, are the parties ready? Okay. All right, would you call the case, please?
Case number SC 2025-0623, Ex parte Mac Bailey Marquette. This is a petition for writ of mandamus to the Morgan Circuit Court. Arguing for the petitioner, the Honorable J.D. Lloyd. And arguing for the respondent, the Honorable Barrett Bowdry.
Thank you. Mr. Lloyd?
Madam Chief Justice, and may it please the court. J.D. Lloyd for petitioner Mac Bailey Marquette. Officer Marquette proved by preponderance of the evidence that he acted in self-defense in shooting Stephen Perkins. This petition isn't truly about disputed facts. It's about this court's de novo review of the law applicable to a series of undisputed facts. A proper application of the law to these facts requires the finding of immunity. This court shouldn't hesitate to issue the writ of mandamus, directing the circuit court to find Officer Marquette immune for two interrelated reasons. Number one, if this court focuses on the central undisputed facts that Perkins unlawfully pointed a firearm at Combs and then Officer Marquette without legal provocation, then it must conclude that the circuit court didn't faithfully analyze the immunity claim under the plain wording of the statute and binding precedent. If this court sticks to the black letter law and its recent decision in Ex parte Johnson, it will find Officer Marquette immune under, at the very least, the duty to retreat version of self-defense. Number two, as a matter of Alabama law, the officer's presence was legal and justified within their scope of duty. To reinforce that conclusion, this court can apply civil litigation principles regarding discretionary authority to the question of scope of duty in the context of self-defense claims involving law enforcement officers. And so, where I would like to start today is the simple plain language of 13A 323 and the duty to retreat version of self-defense. I'd like to put aside the stand your ground version for just a second, because the lower court's focus on the reasonableness of police tactics was inappropriate and insufficient for fully assessing an immunity claim. Tactics are not dispositive of whether Officer Bailey showed by a preponderance of the evidence that he acted in self-defense. And I would turn this court's attention back to its recent decision in Ex parte Johnson, of a very recent restatement of a self-defense case that has a lot of similarities to the present case. So again, I'd like for this court, just for the sake of this portion of the argument, to assume we're not traveling under the stand your ground version of self-defense. That we're just looking at the the duty to retreat version of self-defense.
So let me interrupt you there. The defense of person statute, which is section 23, that's the one that provides for immunity, correct?
Yes, Your Honor.
So if you're on some other portion of self-defense, like the common law or section 27, which is the one about peace officers, that's an affirmative defense, correct?
Yes, Your Honor.
So the judge here was supposed to be deciding under 23, right?
Yes, Your Honor. I think that any self-defense claim has to be filtered through 23, and especially where there's an absence of case law interpreting 27 and how we are to analyze officers' claims of self-defense. Very simple for this court to turn back to the black letter law of 13A323 and the case law interpreting certain aspects of that to see that Officer Marquette did meet his burden in this hearing. So
I'm just trying to understand the structure of the argument. If you want to win on mandamus, you have to show you're entitled to immunity, not an affirmative defense, right?
Sure. Yes, Your Honor.
So why does it matter whether he says has a common law duty to retreat or not?
Well, the question for mandamus was basically, would the court, are the court's findings of fact here, is this court going to defer to those findings of fact, and is it going to defer to the conclusions of law here? And what we believe is that the proper focus is on the undisputed facts and judge the lower court's application of those facts to the law, because this court's standard of review on the legal questions is de novo. So we're looking at a de novo review of the legal questions that the court answered down below. And so when we start to ask those legal questions about self-defense under subsection 23, the court's order just simply cannot stand close scrutiny with the...
So I mean, again, let's say I agree with you that the common law duty to retreat was on the facts applicable. Let's just say I agreed with that. That's still an affirmative defense. You don't get mandamus on that, do you?
I believe you do, because we're still traveling under the concept of self-defense immunity, that this is a claim under 13A323D that has to be read, you know, that while it may be an affirmative defense in 27, 27 still refers back to, inevitably, 23, and that the analysis still has to focus on 23 for any claim of self-defense.
How does that work? I'm very curious about how the peace officer statute under 27, I think to use your words, relates back to 23. Was there a textual basis for that connection?
There's not a textual basis in the current or the version of these two statutes under the context in which this claim arose. The law has changed, as this court's well aware, that 27 has been amended by the Back the Blue Act, and the concept of an officer claim of self-defense has to be analyzed under a different structure today than when we had our immunity hearing below. But I don't think that this court should be troubled by some sort of difference in 23 and 27. That 27 kind of expands the scope, perhaps, of 23, that we look at police officers a little bit differently, that an officer acting in the line of duty. And I think that this court, one of the questions this court could answer if it needs to, we don't believe you necessarily need to answer it, is how does 27 influence the analysis under subsection B of the self-defense statute? How does the court consider, what does it mean when an officer is on duty, or peace officer for the purposes of 27? What is the interplay of the stand your ground language of subsection B with 27 discussing peace officers? So at the end of the day, we believe that the court just needs to come back to 23.
The circuit court, let me ask you this. The circuit court, as I read the order, said I don't think 23 is the appropriate statute to analyze. 27 is the appropriate statute to analyze. Do you think that was error to analyze, to essentially, or am I reading this, the order incorrectly? And if so, do you think that's error?
Your Honor, I believe that that is certainly a way that his order could be read. And I think that when we're talking about claims of immunity involving a peace officer, that 27 is an inevitable part of the analysis. But again, the plain language of 27 doesn't set forth any sort of different test. It doesn't give us any sort of real different points of analysis. It doesn't give us black letter law to think about how the self-defense claim would be different for a police officer versus an individual acting in self-defense.
Counsel, Counsel, the order from the trial court basically found that it was a question of fact whether the defendant was acting within the scope of his employment and whether his actions were consistent with what a reasonable officer would have done in this situation. How does the ultimate finding was that he failed to meet his burden. How does the Ori tennis rule factor into that? How should we look at that? Is that not indeed a question of fact as to whether he was acting in the scope of his employment and his capacity as a police officer?
Your Honor, I think that the question that this court has to ask itself is, what does it mean, scope of duty, scope of employment? These ideas and the concepts of what are the parameters of police?
Is it a factual determination that the trial court has to make, or are you suggesting some legal?
I think that the most direct answer is, when we're talking about the reasonableness of tactics, we have to ask, what is it those tactics show, or what did those tactics do? How do they fit into the situation? Because one thing I would ask this court to do is look at this chain of events and look at what really caused the ultimate use of force. It wasn't tactics, Your Honor. It was a man running out of his house with a gun drawn, pointed at Combs and then at Officer Marquette. This action by Perkins is a causal break in the analysis about tactics. So while tactics might come into some sort of other analysis, I think that this court needs to have the discipline to say, we're going to look at tactics, but we're also going to look at what really caused the use of force.
Are you saying that what happened with the person that was the victim in this case was not reasonable?
That would be our position, Your Honor, that Mr. Perkins unlawfully pointed a gun at Combs. He then unlawfully pointed a gun at Marquette.
Can I ask you, I hear you say he unlawfully pointed the gun at Officer Marquette. I think from a textual perspective, looking at 13A323, one thing you have to show to a point of clarity for us is that Perkins, essentially the Officer Marquette was acting to prevent, let's see, I've lost my language here, but essentially that the use of force he was anticipating was unlawful. I think that's part of A1 under the Defense of Person statute. What about Perkins pointing that gun was unlawful? What makes that act unlawful? If you're coming out of your house on your own property, can you tell us what makes that act unlawful?
Sure. And
Before you start, wasn't this the second time that evening that he had brandished a weapon?
yes, Your Honor, it was. But Justice Parker, to come back to your question, I'd like to just turn to the record. I'd like to turn to what the state's expert, Agent King, said that when Perkins emerged from the house pointing the gun at Combs, he was committing the crime of menacing. I don't believe that there's any sort of construction of the law that could reach a contrary conclusion. When we're talking about factual deference to the court, there's simply no facts.
How can I be menacing if I step out of my house and think someone's on my property inappropriately and I have a gun in my hand? How is that menacing?
Well, it's the threatened use of force here that would have been unlawful under subsection, I believe.
So that's, you can't defend your home? You can't defend your family?
You can't defend your home with deadly physical force or threatening deadly physical force unless certain...
Yeah, you better not show up at my house.
Well, of course, Your
I'm
Honor,
just curious about the legal, so I did find the language here in 13A323. Person is justified in using deadly physical force if the person reasonably believes that another person is, A1 says, using or about to use unlawful deadly physical force. I think you were about to get to it, but is there a statute that makes Mr. Perkins' use of brandishing of that gun when he comes out of his home on his property? What statute should we be looking at to determine the legality of his conduct?
Well, I would take a look at the defense of premises or the defense of property, not the premises, that his actions in threatening deadly physical force wouldn't satisfy those sorts of defense protections that, one can authorize, that in certain circumstances, if you have a home invader that you reasonably believe is about to cause serious physical harm, that you can act in self-defense. But just the idea that someone can use deadly physical force or threaten the use of deadly physical force to stop a repossession, that simply doesn't fit within those protections of the defense, the defenses available for property or for premises.
So Mr. Combs was actually trespassing, though. The driver of the repo vehicle had been told not to come on the property. Right?
I believe that effectively he had been told not to come on the property.
It was very clear, right?
It was
Get off my.
It was pretty clear from the first.
It was very, very clear. Don't come on my property. He couldn't have been more clear, right?
Sure.
And so he came back on the property in the middle of the night.
Yes, Your Honor.
So we can put aside the officer right now, but the repo guy was trespassing.
Your Honor, I don't necessarily believe that is 100% clear under the self-help repossession statute. The black letter law does not allow someone to come back and have a second attempt at a self-help repossession. There's no case law in Alabama that says you're not allowed to try to effectuate a second self-help after a breach of the peace. So
If you've been told not to come on someone's property, that's just trespass under misdemeanor, trespass 3, right?
But if he remained to have the right to repossess that car
It didn't mean you come on my property, though, right?
I think that he still could have potentially repossessed the car without being in violation of the trespass statute. But this is an important distinction that I mentioned earlier that I asked the court to focus on. It's Perkins' actions that set in motion the fatal chain of events. And it's not these tactics. And I asked this court to think about tactics in the vein of subsection C2 of 23C2, and talking about the provocation and who's the aggressor in the situation, what sets in motion. Under Ex parte Johnson, this court could very readily say, look, we've looked at the question of aggression and provocation recently. Police tactics here do not meet that test. They do not meet that sort of dynamic. And again, talking about aggression, this court said that to be an aggressor under subsection C2, someone has to engage in forceful action or an unprovoked attack. And an initial aggressor is not merely...
Mr. Lloyd, your light.
Oh.
I don't think the chief could see it.
I apologize, Your Honor. I'm sorry.
You want to finish your sentence?
If you wouldn't mind, Your Honor, I'll finish that thought real quick.
Don't be like a lawyer and have 5 sentences, just this sentence.
This court said an initial aggressor is not one who just merely created a controversy or verbally confronted someone. So the question that this court might have about tactics, I'd ask this court to look back at Johnson and what it said about provocation and aggression. Thank you.
Thank you, Mr. Lloyd. Dowdy?
May it please the court. The state of Alabama has 2 important interests in this case. One is obviously being able to hold officers accountable for criminal wrongdoing. And the other is also to ensure that officers who do act within the line and scope of their duties have room to act and that they don't fear criminal liability or civil liability for reasonable mistakes that they make. We think that the Court of Criminal Appeals walked that line correctly in its narrow decision, and we would ask for a similarly narrow decision by this court. I want to address the order of operations first and the question of Section 27 and how it relates to Section 23. I think the answer to that is in Darby, that this court recognized, the Court of Criminal Appeals recognized that Section 27 creates the reasonable officer standard that applies and is imported into Section 23. So I think there are 3 questions in this case, and I think Mr. Marquette would agree with this. One is, was he acting in the line and scope of his duties such that he was a law enforcement officer for the reasonable officer standard to apply? If not, then you go to normal Section 23 and you ask, does he have a right to stand his ground? Was he in a place where he lawfully could have been? If not, then you go to duty to retreat. And I want to take that in that order. So starting with, was he acting as a law enforcement officer? I think the case to go to here is Ex parte Selma and the repossession statute at Section 79A 609B. I think both the statute and that case makes clear that obviously creditors have a limited right to self-help repossession. And the statute makes clear that if you're having to turn to the strong arm of the law for your self-help repossession, that's no longer self-help. That is the state coming in to enforce the repossession. And the statute says, if you need the state to come in to help with repossession, you have to go to court, you have to get a court order, and then the sheriff comes along and enforces the repossession.
So, Mr. Bowdry, I have a question about that. Okay, let's just say that in this case, Mr. Combs just showed up, and let's take the first time he went by there, and Mr. Perkins came out with a gun and ran him off his property. Okay, could Officer Marquette, had he been patrolling and driving by and looked out his window and seen that there's a man holding a gun on another man, could he have jumped out of his car and kept the peace?
Yes, absolutely.
Okay, so what's different here in this situation?
Yeah, so what is different? So I think that is the situation of Ex parte Selma. So in that case, the debtor calls the police, says, they're here taking my car. The police arrive on the scene, not of their own making, right? Police have to come to the scene, they take it as it is, and then they respond to it. And in that case, the car had already been loaded up on the truck, which means under the law, the repossession had already taken place. And then the police says, nothing I can do. And that was absolutely right. So in your scenario, if Officer Marquette shows up during the first repossession attempt, absolutely, he can intervene.
But
the difference is...
The facts, as I understand them at issue here, the officers were there to provide security. They were actually taking steps not to, at least in some sense, not to help with the repossession, right?
I think they were trying to get around the law while also allowing the repossession to take place. And so I think this is the opposite of the Selma example or Justice McCool's example.
But wasn't the tradition for Decatur, however you want to state it, wasn't that they did go out? And if a repossessor showed up and said, I need some help, that their tradition was to go out. Is that not correct?
I think two thoughts, Your Honor. One is I think that is disputed. The only evidence, so I think it was Officer McAdam who testified that he had done this once before, but that was during the daylight. He was visibly present. The circumstances were very different. Second, even if it had been a tradition, I don't think that gets them around the law. But
he's just an officer following commands, right? Whatever I've been told to do.
I mean, everyone is clear here that they cannot participate in the repossession. And it's also clear and undisputed that the second repo attempt would not have occurred but for the officers going. So Mr. McCombs, the repo driver, he testifies, this is on page 29 of the transcript. I told Officer McAdam, if I was to go back, I would not go back by myself. Page 31, I told him, if I was to go back, I wanted somebody there with me for my safety. So he's not going back unless the officers go with him. So it is the officers who insert themselves into the situation and facilitate the repossession. That is unlawful.
Mr. Bowdry, is the state relying on Section 79A609? That's the repossession statute. Are you relying on that? You mentioned that there was clear authority here that prohibited the police from being involved in any way with the repossession.
Yes, Your Honor.
Well, I'm looking at the language of that. It says, after default, a secured party may take possession of the collateral. Judicial and non-judicial process, a secured party may proceed under subsection A pursuant to judicial process or without judicial process if it proceeds without breach of the peace. Everything in there refers to a secured party. I see no reference in there to law enforcement. I don't see anything in that statute that in any way helps me understand what law enforcement is allowed to do with a repossession. It certainly does not say that law enforcement in no way can be involved with a repossession. Am I reading it wrong?
I think judicial process in B1, that's the law enforcement arm of this. So when there's a breach of the peace, the repo person can go to the court, get a court order, then the sheriff goes along and helps enforce that order. So
Well, I know that, but I'm looking at the secured party may repossess without judicial process. That isn't necessary going to get a warrant under Alabama law to repossess.
That's correct. If it
But my point about this is this whole statute is talking about the rights of a secured party. Nothing in this statute says anything about whether it is legal for a police department to create an internal policy to place officers in a position to secure the peace generally. So I need for you to somehow tie me into something else if you're going to go forward with this argument about this was some kind of violation of state statute for them to be present during a repossession.
Well, Your Honor, I think it is undisputed. Everyone acknowledges that the law enforcement officers could not participate in the repossession.
Would that be by city policy?
I think that is the law. Everyone looks to 79A609.
Everybody looks at it? I'm looking at it. I'm looking to see where in here it says law enforcement. What I'm seeing is a secured party may do this, a secured party may do that. What I want to know is, am I looking at city policy, the city of Decatur? Is it city policy that we do this? We provide security in a situation where there has already been an incident with a firearm, and the upper echelons of the Decatur Police Department say, well, it's our policy to provide some degree of security when these things are going to happen under these facts. And what I'm struggling with here is that the upper echelon, the superior officers of this officer dispatched this officer to the premises with 2 or 3 other officers. As I recall, a sergeant was there as well, who was perhaps supervising from his patrol car on the street. He's there in uniform. He's there pursuant to a dispatch from his superior officers. You made the blanket statement, a while ago that he was not there acting in the capacity of a law enforcement officer. But all I hear you saying is, well, under Section 79A609, he was there interfering with a repossession. And I'm just trying to figure out what is it in 79A609 that says that he could not be there pursuant to lawful instructions from his superiors. He's in full police regalia. He's in a police vehicle and all that. I understand he was standing in the shadows. We can get to that. That's a totally separate issue. But what I'm zeroing in here, I see a lot of discussion about tactics. I see a lot of discussions about acting reasonably. Was it reasonable to position lawyers here, to position lawyers there? And all of that's fine. But I think if you look at the statutes that we're dealing with, it doesn't talk about whether these tactics were reasonable. It doesn't talk about that. These statutes talk about reasonable perception, reasonable belief. That's the exact wording of these statutes. What did this officer reasonably believe at the point of contact with the victim? So I need a little help before we get bogged down with tactics and whether the police should have done this differently. You need to
Yes, Your Honor.
back up a little bit.
So I want to be clear at the forefront. My argument really does not depend on the tactics. It is simply whether they had lawful authority to facilitate the repossession. And our argument is that they did not. I think that is, and I'll go back to the law in just a second, but to address your concerns about what was the policy of the Decatur Police Department, the only testimony, and I think this was a disputed fact, the only testimony that was presented below was not from the sergeant, it was not from the upper echelons of the police department, it was from the other officers, two of the other officers who were involved in the shooting. We did not hear from the sergeant. It was, I think, undisputed that the sergeant came to the scene. He was driving by right before the event happened. He was not there during the event. He did not tell them where to set up. So that the fact that the sergeant came and then came to the scene after the shooting occurred, I don't think we can put too much weight on the fact that the sergeant was there. But I think that Judge Elliott was within the bounds of his factual finding to take with a grain of salt the testimony from the other officers who were involved in the shooting.
Mr. Baldry, if we look at this text of the statute, so if we're in 23, it says that you have a duty to retreat under 23 unless you are someplace you're allowed to be and not engage in unlawful activity.
Right.
Is it the state's position that he was trespassing on this property and therefore not in a position, a place he was allowed to be under the text?
Yes, Your Honor. That's exactly correct. That because he was facilitating the repossession, and Mr. Combs, the tow truck driver, he did not have any more of the limited right to go and repossess because there had been a breach of the peace. Now, we're not arguing that that right is forever extinguished. If he wanted to go the next day to Mr. Perkins's place of work and snatch the car there, that's probably reasonable. But the repossession...
You go on someone's property to do a repossession after they told you not to come on their property. Is that trespass?
Yes, that is trespassing. And the court has been clear...
Mr. Ballard, let me ask you one thing while you're looking at your citation. Let's assume that he was trespassing. Let's assume for the moment that he was trespassing and he was not where he was, the language of the statute is he was not where he was supposed to be.
Yes, Your Honor.
Correct me if I'm wrong, is the effect of that finding that he cannot, he would have to retreat?
If he's safe, if he can.
Okay. Now that gets me this. So is that material to our inquiry here, given the testimony that all of this transpired probably in a blink of an eye, seconds? If this police officer, whether he's there properly, whether he's trespassing, whether there should have been some other plan formulated by the Decatur Police Department to handle this all happens like that.
So
is he have under a burden at that point to retreat, or does he have the right to protect his life?
So he has the burden in this proceeding to show that he could not have retreated. And unfortunately, this just did not come up below. If you search the record, do a Control-F search of all the exhibits that Mr. Marquette attaches to his mandamus petition, search for retreat, I got 3 results. Every one of those was Mr. Marquette arguing that he did not have a duty to retreat. So I think it's pretty hard for him to argue that he has a clear legal entitlement to something that he never addressed before the trial court.
Mr. Baldry, along those lines, going back to your position, and I believe it's the state's position that Officer Marquette was trespassing.
Yes.
He was not acting in his capacity as a police officer because he was not allowed to be where he was, correct? Okay.
That is correct.
All right, let me just, for the sake of argument, there were other officers there, at least one of which was in the public road, correct?
I think Officer McAdam, Officer McAdam was in a driveway across the street, and the sergeant is walking up, I assume the public road, but I actually don't know.
Well, let's just assume for the sake of argument that one of the other officers was on the public road. And let's just say that this officer standing in the public road, sees Mr. Perkins pull his gun and point it at Mr. Combs, and then maybe turn and point it at himself or whatever, would we be here if he had pulled the trigger?
I think that would at least be a much different and much closer question.
So it's just a matter of feet and geography at this point? Is that, would
I mean,
would you
that's
say?
always true for trespassing, whether
Okay.
you're on someone's property or not, is binary. But I think it also is the intent. Were they there to facilitate the repossession? And then you're looking at the totality of the circumstances. And so I absolutely agree. The 1.5 seconds of the video that Mr. Marquette focuses on, obviously that is relevant. Our argument is simply that we should be able to go to a jury and have the jury determine whether he was acting in self-defense at that time. And the burden for us at that point would be very heavy. We would have to prove beyond a reasonable doubt that he was not acting in self-defense at that time. Not focusing only on that 1.5 seconds, though. Focusing on the totality of the circumstances, everything that happened that night. And I think
Is it fair, Mr. Bowdry, back on the trespassing thing, Perkins never told the officer, never gave him a no trespass order like he did Combs, correct?
Well, you're right. I mean, Mr. Perkins had no idea that the officers were there until he was shot by them.
But yet he's a trespasser, even though he's not being given a no trespass order based on some contingency of what was told Combs.
I think,
Is that the theory, or?
so I think this goes into the intent of why they were there. So people have the right to walk on another person's property for certain circumstances. So if you're there to do a repossession.
I understand, but in fairness, no judge or magistrate would have given Perkins a trespassing warrant against the officer, maybe against Combs. Wouldn't you agree?
Well, I think
He'd never been told, leave and don't come back.
Well, I think, if Mr. Combs had gotten a friend, a different friend than the one that he had with him in the truck the first time, and he had given that friend a gun and said, all right, come on with me, I want you to stand in the bushes, and when Mr. Perkins comes out and points a gun at me again, I want you to shoot him, I think that person is trespassing, and that any shooting would, probably be unlawful.
That sounds more like a conspiracy to commit murder than
Okay,
a simple.
take away the gun, even if he just has the friend come with him and,
I'm just struggling with
for
calling
support.
an officer a trespasser. I'm fair with you. If none of this shooting had happened, I think a jury would convict Combs of trespassing for coming back a second time. But I'm still having trouble how a jury would convict the officers who were on the property of trespassing, because my belief is it either needs to be posted or you need to verbally or in writing tell someone.
I think this goes back into the why are the officers acting as officers at that point, or are they there to facilitate the not the trespassing, to facilitate the repossession? I agree. Most of the time, law
That goes
enforcement
back to
officers.
Justice Shaw's point that actually the statute does not affirmatively state that they cannot assist. I mean, assisting, facilitating, what they can't do is what a sheriff would do with the writ of possession, which is prohibit Perkins from interfering with the possession. So the judge would have to be concluding that they were prepared to interfere with Combs's repossession by physically stopping Perkins from.
Yes, Your Honor. So I think, to the extent that you think that the statute does not expressly cover this, I would just say the case law across the country. I mean, these are old rules. They were common law rules. Now they're codified. The case law across the country is pretty clear that courts across the country make the dividing line between, is the officer there stumbling upon a scene not of his own making, or is he there having created the scene and having, again, I'll cite a Kentucky case. If the strong arm of the law is needed
Are we
in the creditor.
perhaps blurring negligence and perhaps a good wrongful death claim about Perkins with criminalizing what appears honestly to be negligence by the city?
Well, so I think, if I can make one more point, I think my time's about to expire, but if I can respond to
Fair
you.
enough.
I do want to be clear that we're not arguing, our argument does not depend on the tactics that were used. Our argument is not that if an officer is negligent at point A, then any kind of officer-created danger that he has to respond to at point B that he's limited. That is not our argument, and we reject that argument. We're in federal court all the time arguing against that. Our argument here is simply that Officer Marquette was not acting as an officer when he went to facilitate the repossession that would not have occurred but for his presence. Unless there are further questions, we ask the court to deny the petition.
Thank you, Mr. Bowder.
Thank you,
Your
Your
time
Honor.
is up. Mr. Lloyd?
Mr. Lloyd, before you get started, you ask us that we should find that the officer was immune. Based on the posture of this case, can we actually do that? Can our court find the officer immune, or would it be more in line for us to send it back to the trial judge with some specific things they should do to reach that finding?
I don't believe so, Justice Sellers. I think that the record below was very well developed. I think that this court can look at both the circuit court's order and the factual questions that it did answer, and then it can look at the factual questions that it didn't answer, because this court is to presume under Fitzner that any sort of factual determination that is unstated would support the court's ruling. So if the court didn't speak to that factual issue, this court needs to assume that the facts were determined in support of the order.
Mr. Lloyd, what material facts are disputed here? Material being the key word there.
Justice Shaw, I don't believe there are really any disputed material facts here. I think that the question that is central to this case, that's central to self-defense, that we really haven't had a chance to explore, was the ultimate use of lethal force by Officer Marquette.
But you would dispute that the officer was trespassing, right? You're disputing that.
I would dispute that, Justice Cook, but the reason I wanted to start with the duty to retreat version of self-defense is I wanted to get outside the question of trespass, the question of...
But I can't get outside that, right?
You can, Your Honor, because if he's a trespasser, if there's some sort of principle of trespass that comes into play here, if there's some sort of clear legal rule that he can't be present during a repossession, which we don't think that the law says that, but we get into the question of the duty to retreat version of self-defense. We're simply just outside the question of stand your ground immunity. And I think that
just to be clear, y'all argued at the trial court in the transcript that he wasn't a trespasser because his intent was not to be trespassing, right? You used that word in the transcript. I'm sorry, your side used that word in the transcript.
I believe so, but I think that the question...
That would be a factual dispute, right?
I don't believe so, Your Honor, because the question is, were the officers there, were they lawfully present, were they lawfully there? I think that under the plain wording of the self-help repossession statute in Ex parte Selma, this court could readily say, officers have the ability to keep the peace in a repossession.
That's an intent question, whether they were there to keep the peace. They were there to keep the peace. Arguably, they should have knocked on the door and had their lights on and said, hey, we're here to keep the peace. Instead, they hid in the bushes and hid behind the house and were whispering on the video. That's at least an intent question, whether they're really keeping the peace and that was really their intent or not.
Your Honor, I think in an alternative fact set, perhaps, but what we have here is this intervening act by Perkins, that Perkins immediately left the house with the gun drawn, and this set in motion the ultimate question that this court should be focusing on. Was this ultimate use of force reasonable? And this court can readily conclude with the videos, with the still photos, with Agent King's testimony that Officer Marquette faced lethal threat in that moment, and that his use of force...
Mr. Lord, follow up on that point. In your petition, you say, you have a heading that says, even if Marquette trespassed or was otherwise engaged in unlawful behavior, he is still entitled to immunity. Help me understand, assuming that I'm right, he was trespassing or engaged in unlawful activity, why he still gets immunity.
I think that the best way to think about it is, one way that he can prove immunity is stand your ground. If he doesn't satisfy the plain wording of subsection B, finds that he doesn't satisfy that, we move to the question of, well, can he satisfy the duty to retreat version of self-defense? It's, for lack of a better term, it's a lesser included defense.
So in other words, you say if he doesn't satisfy these two, unlawful behavior and where he's supposed to be, we go to the common law duty to retreat, which is, can you do it safely?
Yes, Your Honor. And I think that when we talk about disputed...
Not safely, without increasing your danger, right?
Right, without increasing its peril. And I think that that's where this court has to pay attention. It has to focus in of the factual determination here that effectively the circuit court passed on, but that this court can assume. Officer Marquette reasonably perceived the need to use deadly physical force when someone unlawfully pointed a gun at him. And this court can conclude that he could not retreat safely in that moment.
Mr. Lloyd, I have a question that I'm troubled by. We're here on a mandamus, a writ of mandamus. We're not a fact-finding court, okay? And I keep hearing all these questions about intent and intervening act, causing the shooting, that sort of thing. Tell me how we're not here on an appeal. It's a different standard. So you have to have a clear legal right to relief. As I read that, there can't be any factual disputes that we have to try to figure out what they are.
But I would turn Your Honor's attention back to Fitzner and looking at the undecided factual questions have to be, this court has to assume that the circuit court ruled in a way that would have supported his order. I see my time has expired, Chief Justice. May I finish this thought?
Sorry, Justice Shaw would like to ask you one more question. You can finish your statement to Justice McCool and then answer Justice Shaw's question.
I think that this court doesn't need to interpret silence as factual questions that need to go back and be answered by the circuit court. I think that under Fitzner, this court can make a decision of whether or not the undecided factual question or the unspoken factual issue that wasn't included in the order went against Mr. Marquette and went in support of the order. But then this court can look at the evidence.
Hang on, Mr. Lloyd, stop there. Answer Justice Shaw's question.
Sorry.
That's okay.
I think I understood Mr. Bowders to argue that there is at least a fact question as to whether the police officer should have made some attempt to withdraw from the situation. As I read these statutes, I think that is a very important question for me as I analyze the interaction of these two statutes that we're trying to deal with here, because it goes to the question of retreat. So I'm in a position, and I think you have recognized that, and this is what Justice McCool is talking about. We have whatever testimony we have, and we have an Ori Tennis finding, I think, here by the trial judge, but we have body cam footage. Is it your position that we, as an appellate court, we don't find facts? Are we able to look at body cam footage and make a determination as a matter of law that that the police officer had no opportunity to evade harm or die?
Yes, Your Honor, you do. This court has the duty to look at factual questions and decide if they were clearly erroneous. And it would be clearly erroneous for this court to conclude that Officer Marquette did not perceive the threat of lethal force and did not reasonably perceive the need to use lethal force in kind.
So if we look at the body cam footage and we see the deceased point a gun at the officer or the repo driver, and we see that officer lit up with the light from the gun, okay, and we look at the little timetable on the body cam footage. So your argument, just so I understand it, not passing on it, I just want to understand it. Your argument is that if I look at that body cam footage, that I should be able to say as a matter of law that this officer had a reasonable belief that he was about to be shot. That's your argument.
I believe so.
The state's argument would be different, but that would be your argument.
That would be our argument, and that it was clear error for the circuit court to have concluded otherwise.
Thank you, Mr. Lloyd. All right, I appreciate y'all's briefing and your arguments today. We are going to take this case under submission, and we are...
All rise. Please be seated until all parties involved in the case have left the concert hall.